All right, good afternoon, everyone, or good morning, depending on where you're at. Welcome to Pacific Legal Foundation's What's at Stake panel discussion today for Wilkins versus United States, our upcoming Supreme Court case, which will be argued on November 30th of this month by none other than Jeffrey McCoy, who's joining us today. I am an attorney with Pacific Legal Foundation. My name is Ethan Blevins. I'll be moderating today's panel discussion. And I'll introduce our panelists before giving them some time to discuss the case a little bit. And then we will have ample opportunity for Q&A. And please do post your questions in the Q&A box at the bottom. We'll be sure to get to those. So our panelists today are Jim Manley, Jeff McCoy, and Jonathan Wood. Jim is an attorney at Pacific Legal Foundation, where he serves as an attorney manager and litigates in defense of free speech and economic opportunity. In his first case after graduating from law school, he sued his alma mater and won at the Colorado Supreme Court, guaranteeing the right of self-defense on college campuses. And since then, he has successfully challenged many unconstitutional laws, including striking down part of the Kentucky Constitution, saving a man from jail for the crime of repairing windshields, preventing a foster child from being ripped away from her pre-adoptive parents because of her race, defending the right of a midwife to use the title she spent a lifetime earning, and helping to enact laws protecting freedom of speech on college campuses. His work defending free speech, the right to keep and bear arms, taxpayer rights, and property rights has set important precedents for liberty in state and federal courts across the country. Jim joined PLF in 2018, to advance the fight for liberty with the most impactful public interest law firm litigating today. And before joining PLF, he litigated at the Goldwater Institute and Mountain States Legal Foundation. Jeffrey McCoy, who will be arguing the case on November 30th, also an attorney with Pacific Legal Foundation, where he represents Americans fighting back against excessive and unlawful government regulations. Jeff joined PLF in 2017, and since then he has focused his litigation on separation of powers and private property rights. Jeff also leads PLF's Coastal Land Rights Initiative, which seeks to strengthen and defend statutory and constitutional protections for coastal property owners across the country. And throughout his career, Jeff has worked for various organizations that promote individual liberty and limited government. Prior to joining PLF, Jeff, like Jim, was a staff attorney at Mountain States Legal Foundation in Lakewood, Colorado for 5 years. His work at Mountain States included helping secure victory for a Wyoming private property owner in U.S. Supreme Court case Marvin M. Brandt Revocable Trust versus United States. And finally, our third panelist, Jonathan Wood, a former PLF attorney who is now Vice President of Law and Policy at the Property and Environment Research Center. Jonathan has litigated environmental and property rights cases in the Supreme Court of the United States, federal and state appellate courts, and trial courts across the country. His writing has appeared in the Wall Street Journal, Washington Post, National Review, Reason, and other outlets. And his research has been published in journals such as the Environmental Law Reporter, Yale Journal on Regulation Notice and Comment, Pace Environmental Law Review, and California Western Law Review. And prior to coming to PERC, Jonathan was a senior attorney at PLF, and he litigated cases concerning the Endangered Species Act, Clean Water Act, and other federal environmental laws. He was co-counsel for Forest Landowners and Weyerhaeuser Company versus United States Fish and Wildlife Service, in which the Supreme Court ruled unanimously that private land could not be arbitrarily regulated as critical habitat under the Endangered Species Act. He has also led a successful effort to reform regulation of threatened species to better align the incentives of private landowners with the interests of rare species. And Jonathan has testified before several congressional committees on wildlife conservation and endangered species topics. He's also appeared on national television and radio, including NPR's All Things Considered, C-SPAN's Washington Journal, Stossel, Fox News, and Hill TV, among others. So I'll start by giving each of the panelists a few minutes to discuss the case and its broader policy implications for private property rights and access to public lands throughout the West. So Jeff, let's start with you to provide an overview of the case, please.
Yes, thank you. And thank you everybody for being here. This case, PLF represents Will Wilkins and Jane Stanton. They live in rural Montana, about an hour and a half south of Missoula, next to the Bitterroot National Forest. Jane moved there in the early 1990s. Will moved in around 2005, and things were pretty quiet. But about a decade ago, the Forest Service decided to make this road. There is a road that goes across their property that was granted to the previous owners for limited use, mainly for grazing or logging operations. But about a decade ago, the Forest Service decided to open it up to everybody. And since then, there has been a lot of issues. There have been thefts on Will's property and their neighbors' properties. There have been people going at high speeds. There have been someone ran over Will's neighbor's dog. Someone shot Will's cat on this road. And when Will, Jane, and their neighbors reached out to the Forest Service, they said, well, we have an easement, anybody's allowed to go on it, and we don't have to do anything about the excessive use. And that's when PLF got involved and filed this lawsuit to define who's allowed on the easement, who's allowed on the road from the Forest Service perspective, and what's the Forest Service responsible for. Unfortunately, the district court, before we could even reach those questions and resolve this dispute about who owns what, dismissed the case, said that it was out of time, and the district court did this, said that it was an untimely case without holding any hearing on it, and just taking the government at its word that, oh yeah, they knew that this was, despite all of the Forest Service's actions, Will and Jane knew that this was a public road years ago. But that's not true. We have lots of witnesses about that. But because the court dismissed the case for lack of jurisdiction, there wasn't any evidentiary hearing or any way for us to make our argument. And this jurisdictional basically means that it's dismissing the case. It means the court can't hear the case. It means the plaintiff, in this case, Will and Jane, have the burden of proving everything. And that's the question that the Supreme Court is taking up. Is the statute of limitations, the time limit, jurisdictional or not? If we win, what that means is that the government will have to prove, after an evidentiary hearing, that the case that Will and Jane was filed at a time, which we think that we have a good opportunity to prove that it was timely. There's also some other factors that the court might consider to allow the case to go forward. And that is the main issue, is really getting into the courthouse doors. This case was brought under the Quiet Title Act, which allows private property owners to sue the federal government to resolve disputes over who owns property. And in passing the Quiet Title Act, the Senate report said that there was grave inequities because prior to the Quiet Title Act, there was no way to resolve these disputes. The property owners just had to wait, and maybe if the federal government decided to sue them, that would be the only way. And Congress explicitly said that this act was to open the courthouse doors so that these can be resolved. And this case demonstrates how procedural rules and different framings of those procedural rules prevent the actual problem from being resolved.
Thank you, Jeff, for the overview. Jim, can you provide us some background on sort of the role of property rights, the importance of those rights, and how this case touches on those interests?
Yeah, thanks, Ethan, and thanks, Jeff, for the intro, and thank you, Ethan, for the introduction. I think I speak for everyone here at PLF when I say we think that property rights are human rights, and that courts should treat them like any other fundamental right that's protected by the Constitution. And in fact, I think property rights are fundamental to all other rights as well. One of the delegates to the Continental Congress, Arthur Lee, explained that fundamental principle when he said, quote, "The right of property is the guardian of every other right." And the Constitution makes good on that principle. The Contracts Clause protects property. The Fourth Amendment protects property from unreasonable searches and seizures. The Fifth Amendment's due process and takings clauses, of course, are directly enlisted to protect property all the time. The Eighth Amendment's prohibition on excessive fines protects personal property. The 14th Amendment's privileges or immunities, due process, and equal protection clauses, also instrumental to protecting property rights. All of these provisions of the Constitution secure property against confiscation, deprivation, and overregulation by the government. Justice Kennedy captured this principle in his typical soaring rhetoric when he said, quote, "Property ownership empowers persons to shape and to plan their own destiny in a world where governments are always eager to do so for them." He called property rights necessary to preserve freedom. And I mean, after all, if you don't control or own the land that you're standing on or the body that you inhabit, you can't very well set up a printing press or resist an unconstitutional search or defend yourself with arms. And so property rights aren't just a necessity, but it's consistent to protect property rights along with other human rights because, as Justice Potter Stewart said, the right to enjoy property without unlawful deprivation, no less than the right to speak or the right to travel, is in truth a personal right. That's because property doesn't have rights. Individuals have rights to own and possess and use property, whether it's real property, personal property, or intellectual property. However, since Caroling Products footnote 4 in 1938, the Supreme Court has deemed itself without authority to strike down economic regulations, including those affecting property, because the so-called rational basis test is used by courts to rubber stamp property rights violations without serious judicial scrutiny by the courts, like they apply to other enumerated constitutional rights. PLF has been fighting this since 1973, when it was formed. Property rights have been PLF's signature issue since the beginning. 12 of our 16 Supreme Court decisions are rooted in property rights. And both of the cases that PLF has at the court this term, Wilkins and Sackett, are about protecting property rights. We've had great success stopping unconstitutional permitting conditions. Nolan and Kuntz are two cases that protect property owners from being extorted to provide things and property to the government in exchange for the right to develop your own land. We've been able to affirm the right to judicial review of decisions affecting property rights in the first Sackett case and in Hawks, both cases dealing with the Clean Water Act. And we've also been successful in opening federal courthouses to property rights challenges. Nick versus Township of Scott opened the courthouse doors to property rights claims, and Pactel versus San Francisco, which Jeff won, was instrumental in preventing state administrative processes from stymieing property rights claims as well. And in Wilkins, we have the opportunity to keep those courthouse doors open when the federal government invades private property. But there is a lot of work left to do to restore property rights to their proper place in the constitutional order. The first step in doing that, or the fundamental step in doing that, is to have courts recognize property rights as fundamental rights and to subject them, any deprivations of property rights, to real searching judicial scrutiny, the type of scrutiny the court applies to other rights that are protected by the Constitution. But even more practically, reforming things like regulatory takings, where the court applies a test established in the Penn Central case that involves a multi-factor jumble of considerations that Justice Thomas has said nobody, courts, litigants, governments, no one understands how to apply this test. One way we've fought back against that jumble of subjectivity is to establish that many regulations involve physical invasions of property, even temporary or sporadic invasions, as we did in Cedar Point versus Hassett. where we established that a statute giving unions the right to enter private property without compensation was itself a taking. Opening the courthouse doors was a tremendous step in the right direction, but now we're fighting the concept of state sovereign immunity from suit. Can states simply avoid paying compensation because of their typical immunity from suit, or do they have to pay compensation when they take property without compensation? Does the public necessity doctrine allow the government to destroy or occupy private property in the case of a quote emergency? I talked previously about exactions during a permitting process in Nolan and Coots, but what about exactions that are imposed by the legislature, by the city council or the state? Courts don't apply the same rigorous review of legislative exactions as they do to permitting exactions, and we're fighting to change that. We have to restore the public use clause to its original public meaning. In IJ's Kelo versus New London case, the public use clause was contorted into the public purpose clause, and takings for purely private gain were authorized by the court. And reversing that, returning the public use clause of the Fifth Amendment to its proper place, would have tremendous benefits to property owners and to the society at large. We're fighting things like rent control and regulations that prevent the production of housing, both of which contribute to the tremendous cost of housing and the inability of folks to find good and adequate housing in many places. I mentioned our work in the Clean Water Act area. Many environmental laws meet the real world in their regulation of how private property is used. And so we've dedicated ourselves to fighting to expand protections for private property in the environmental context, to strike that balance between environmental protection and protection of property rights. And we're also fighting unjust burdens from excessive fines and forfeitures. And of course, the Fourth Amendment's protections for unreasonable searches and seizures are also is an area where PLF is fighting back to protect private property rights. All of those efforts are dedicated to this fundamental idea that property rights are fundamental. And I have genuine hope that we will see a restoration of property rights to full constitutional protection in our lifetimes, thanks to the work that PLF is doing and that many others are doing to fight for property owners in the court of law and in the court of public opinion.
Thanks very much, Jim. Jonathan, let's turn to you. Anybody who lives in the Rocky Mountain West or grew up there like I did knows that living next to public lands is always a hazard. You run into all these kinds of issues. What would the Wilkins case mean for these common conflicts that occur over access to public lands in the West and elsewhere?
Yeah, thanks, Ethan. Not just a hazard, but a tremendous source of value. A lot of people would not live in the Rocky Mountain West if it weren't for the incredible outdoor recreation, hunting, and other opportunities that public lands provide. That said, mostly by historical accident, accessing public lands is really difficult in many places throughout the West. So I think the clearest example that I'll throw out, and that could significantly be affected by the outcome of Wilkins, is an area about an hour and a half northeast of Bozeman, where I live, called the Crazy Mountains, where the land is allocated in what's known as a checkerboard pattern, which is pretty common throughout the West. When Congress was encouraging railroads to build out tracks across the country, they basically gifted the railroads every other section of land. So you end up with these, what really looks like a checkerboard. It's private land, public land, private land, public land. And if you think about that layout, how do you access the internal public lands? There is no means by which you can, while staying only on public lands, get to the interior places. And the Crazy Mountains are a perfect example of that. It is a hugely valuable area for outdoor recreation, for hunting. But there are currently only two legal means by which you can actually access the interior of the mountain range because of those inabilities to jump over the private lands to get to the public lands beyond them. However, because of the growing interest in economic value of outdoor recreation, there have been growing incentives for the Forest Service to work with landowners to resolve some of these conflicts and to provide public access in a way that doesn't have to come at the expense of private landowners. Up until recently, the general model was, well, if we want public access, people should just go out and take it. Under the prescriptive easement doctrine, if you trespass on private land enough, you eventually create an easement that the public can use. And there was a lot of that happening throughout the West. But the unfortunate product of that is that just makes public access a source of conflict. Landowners then have every incentive to try to block access. It can get pretty nasty pretty quickly. So instead, the Forest Service has generally tried to move in more the direction of what kind of access can we negotiate. But it takes a really, really long time to negotiate access with a federal agency. And the crazy mountains, the conflicts have been going on for 30 years. As the Ninth Circuit held, you have 12 years to bring your property rights claims, and after that, you are permanently barred from having your day in court. There's going to be more incentive to litigate those cases rather than negotiate and compromise, and that's going to be lose-lose for everyone. The basic incentives that you would create is, if you're the government, you should be really cagey about what rights you're asserting, so that the landowner never really knows when that clock is starting. And from the landowner's perspective, the incentive is immediately rush to court, because you don't want to bear the risks. The court will say you're too late. So the moment negotiations start, immediately escalate the conflict into litigation. And the reason why that's bad for everyone is that it is inherently, in the best case, it's win-lose. Someone's going to win, someone's going to lose. But when you factor in the cost of litigation, the time spent in litigation, especially over something that's, doesn't have to be a huge source of conflict, like a trail or public access, ultimately, both sides are going to lose. Not everyone is going to get pro bono representation from groups like Pacific Legal Foundation. For a lot of landowners, defending their rights are really costly. And so a rule that's more flexible and that says that landowners have to have really clear notice before the statute of limitations starts and that the incentive to litigate exists are going to allow for more time for the Forest Service and the landowners to have frank conversations about what public access might look like, what rights they think they have, without immediately needing to escalate those conflicts. And if we're going to expand public access to places like the crazies, the only way to do it is at the negotiating table, not in the courtroom.
Thanks very much, Jonathan, for that background. We already have some great questions in the Q&A. I'm going to start with one question that's sort of preliminary, not go in order here, because I think it is important to kind of understand the background here. The Quiet Title Act might strike some people as kind of an oddity. If you have a property dispute with a neighbor, you don't go to a statute. It's usually like common law protections, various things that resolve that. So one of the questions here is, what is the Quiet Title Act? And I'd add to that, why do we resolve disputes over property with the federal government by this statutory means rather than, you might resolve it with a neighbor or so forth?
Yeah, the term quiet title, it's a lawyerly term, but it basically means that a court is going to say, this person owns this person owns this. And as Ethan said, this is a common law thing, and most states have statutes about it. If you and your neighbor disagree about where the property line is, there are many ways to go about it, but you can quiet title to determine exactly who owns where. But there's a concept called sovereign immunity, which means that someone can't sue the government without the government's permission, which means that the government has to waive its sovereign immunity. And with the Quiet Title Act, that's what Congress did. It said this doctrine, which goes back to the King of England, this doctrine is not going to prevent you from resolving your disputes about whether the federal government owns something or how much the federal government owns on your property in a case of an easement. And one line from the Senate report said that the doctrine of sovereign immunity isn't applicable when the purpose of courts is not to protect the government, but to protect citizens. And that's what it did. That's what the Quiet Title Act did, and it allowed people, when there's a dispute like this, to go to court. Because prior to that, there was no way. The federal government could come and say, I own this, and if the private property owner disagreed, there wasn't a mechanism to get into court for that. There may be some if it's a taking, but as Jim said, what constitutes a taking is always hard to prove as well. That was the only other way that you could even get compensation, but you couldn't get your land. You couldn't say, I've owned this, I've always owned this. At most, you could maybe get some compensation for that, but that's what the Quiet Title Act is and what it does.
Right. Thanks, Jeff. Just another related question before we go into some of the great questions here. 12 years seems like a long time in comparison to a lot of standard statutes of limitations, a couple of years. Or why is the statute of limitations so long here, and why isn't it adequate to protect property rights just to have that firm bar, but allow for considerations about, for example, when the property owner really should be considered aware of what's going on, when the government might say, no, don't worry about it, we're still going to negotiate that. Why are those factors important when we already have such a long statute of limitations?
Yeah, well, I'll start. I think the reason why it's so long is because Congress wanted private property owners to be able to resolve the disputes. But and while 12 years is longer than many statute of limitations, as Jonathan says, these things can go on for 30 years. And another aspect of that is, especially in the West, when there is a lot of land, there may be times where a private property owner doesn't know that the government believes it owns something. Or in the case of Will and Jane, they knew that there was an easement, but the documents about the easement said this was for limited purposes, and they saw only limited purposes. And then suddenly the government says, oh, we've always said that anybody can come on. And we've always had the position that if the public's causing trouble, we don't have to do anything. And that's what happens, is that these conflicts can either go on a long time, like Jonathan said, or there can be, no one can know that there's actually a conflict until something dramatic happens. And in that case, the government will say, oh, well, you should have brought this 20 years ago, even though there was no problem until now. And you don't want people rushing into court. You ideally do want people to negotiate and deal with these problems. But as Jonathan said, if this is strict and there's strict rules and strict procedures, you're going to get more people suing the federal government because they think, okay, the government might think they own that. Let's clear it up now rather than go to court.
Yeah, I'll add that in a lot of these public access and property disputes, there's not a clear starting point from which the clock can run. Like statute of limitations make obvious sense if you're talking about litigation over a car accident, because you had the car accident, that was a fixed point. It even makes sense, imagine a situation not like Wilkins where there's no easement, but the government just builds a road across your property. Like that obviously notifies you that the government is asserting it can build a road. But a lot of these conflicts are incredibly vague. They might involve a depiction of a line on a map that you can't really tell whether it's on your property, but it might be really unclear situation. So in the Crazy Mountains, most of the landowners are happy to provide access if you ask them for it. Well, how do you calculate that? When they consented to allow the access, does that cut against them? Is that the point when they should know the public wants to provide property? The government wants that access. So really the challenge is those cases where there's not a clear point by which you can say, obviously anyone would know. And if the statute of limitations is jurisdictional, those are the people that are harmed, the ones that, well, how was I supposed to know that there was this map the government never sent me that might not be on my property? It's really those complicated situations, unclear situations where this matters. And those are also situations where it makes the most sense to negotiate. If the government built a road 20 years ago, 30 years ago, there's not really a point in arguing or negotiating of whether the road gets to continue to exist. It's when there are these unclear changes that happen at some uncertain point that negotiation can be most valuable.
Well, yeah, and I think it's important to remember that we don't want people running into court prematurely, but oftentimes people can't run into court prematurely because, as Jonathan says, the dispute isn't live yet. And if Will and Jane had sued, say, before the travel management process, the Forest Service position at that point was, we're going to close this road. So at that point, they may not have even had a claim. And then the travel management process took 8 years. And then only after that did the federal government take really affirmative action to say, yes, this road is open to the public, and to post signs and to take other actions that made their position very clear. So yeah, when you're talking about an easement, you have reciprocal rights. You have the whole idea of an easement is that the property owner and the easement owner coexist and work out their differences. But when it's the federal government, there's no opportunity to work out the differences. After 12 years, the default is you lose. And I think it's telling that in the Ninth Circuit, Judge Van Dyke suggested that the way to resolve these disputes is to just block the road. A federal judge is suggesting that maybe a range war is the way to solve these problems. That to me suggests that the courts are misinterpreting the Quiet Title Act. Particularly when you consider that Congress didn't even include a statute of limitations in the first consideration. It was the Department of Justice that encouraged Congress to add that, and Congress added a long statute of limitations that based on the text, structure, and history of the act should not be read as a jurisdictional bar. And so I think the court has a great opportunity here to really enact the will of Congress and reform this misinterpretation that some of the courts have applied to the Quiet Title Act.
Another question that I think is worth addressing here that kind of runs to some of the broader property rights themes behind Wilkins. How can the government just decide the road is public when it's on their property? Are there other examples where the government has successfully done this sort of thing to people?
Yeah, well, and like I said, the original negotiated easement was for limited use, and policy changes, Forest Service policy changes, and more people want to use the resources and go onto public lands, and the Forest Service and other agencies have reflected that. But instead of negotiating, sometimes they just say, well, we have it. We already have it. And instead of renegotiating with the landowners for that. And there are examples, as Jonathan said, where the Forest Service has negotiated and done so properly. But yeah, there is other examples. Ethan mentioned when I was at Mountain States, I worked on the Brandt case, and that was another case where there was landowners who had a railroad easement across their property, and the railroad went out of business and abandoned the easement. And traditionally, if someone has an easement over your property and they abandon it, then there's no more easement. But the federal government came in, the Forest Service came in and said, no, the railroad doesn't have this easement anymore. Now it's ours, and we can put a trail in here. Fortunately, in that case, that went all the way up to the Supreme Court. The Supreme Court said, no, this is an easement like any other. It was for this purpose. That it's not being used for that purpose anymore. It doesn't suddenly go to the government just because you originally granted the easement decades ago. And so, yeah, there are examples, and it does, especially when you're talking about an agency as big as the Forest Service. I think it really depends on each national forest individually, because there's a lot of people who work on that, and really it can be the agency can take the approach of, yeah, we own everything, you've never owned anything, to respecting private property rights on the other hand, like in the crazies, where they want to reach a mutually beneficial decision.
Thanks, Jeff. This question might, I'll direct it to Jim first because it touches on sort of the broader themes for property rights and what a victory here might mean. So what would a victory in this case mean overall for property rights in the United States?
Well, as I suggested, I think this case builds on the theme of expanding access to courts to resolve property disputes. And there are something like 600 million acres of federal land that would be affected by this ruling. And wherever those many acres of federal land interact with private land. And that is typically happening all across the West, where the federal government owns a tremendous amount of the land proportionate to the amount of private property there is. And there's a great deal of private property that's intermixed, as Jonathan pointed out, given the checkerboard pattern private property that's intermixed with public property. And so you have these sorts of disputes arise all the time across the West, and there's no way to resolve them if the 12 years have run. And given how subtle the trigger can be to start that period running, many of these claims will have run before they can get into court and before they can be resolved. So the end result is that, as Jeff suggests, if the federal government wants to respect private property rights, it can. And if it decides that it's more expedient to argue that the time limit has run and they don't have to respect the property rights claim that the owners are making, they can ignore it. And they have that ability to do that if the Quiet Title Act statute of limitations is read as a jurisdictional bar and blocks those claims from being heard in court. So the upshot for folks who have private property that's intermingled with federal property is that those rights actually matter and that they can get into court to protect them, whereas now many of those claims are barred because of the passage of time.
And I'll also add that it is not just private property owners. We got a friend of the court brief from a group of local organizations that were in favor of our position because there are conflicts between cities and the federal government. There's one recent example, the city of Santa Monica. The federal government gave the city of Santa Monica airport, and it's not really being used anymore. And so Santa Monica wanted to abandon it, and the FAA said, no, we granted this to you and you have to operate it in perpetuity. And Santa Monica sued under the Quiet Title Act to define what this contract, and it was dismissed because of a lack of because it was outside the time limit. And so it's not even just private property owners, it can be government, local governments as well.
The one thing I'll add, picking up on a thread that Jim started, that really what's at issue here is sovereign immunity. Like if the Wilkins, if PLF wins, it ultimately will be even-handed. Right now, you have to sue the government within 12 years, but the same isn't true of the government. If the Wilkins had put a locked gate over the road and managed to not be noticed for 15 years, that wouldn't stop the federal government from being able to go in and say, we have property rights here, we have an easement, you can't block it. And so providing that even-handedness so people have a reason to negotiate. Like, it is important that the government be able to protect its property rights, the private landowner be able to protect its property rights, and putting a hand on the scale to favor the government is simply unfair.
Thanks. Jonathan, I think this question would be a good one to be directed to you first. It's sort of a broader question about what to do about public lands in general. What would you like to see the government do regarding access to public lands? What do you think the ideal solution would be?
I mean, I think I've kind of already said it. It's what they're doing in the crazy mountains right now. That, you know, we're where we are due to historical accident. It never made sense to have this checkerboard pattern with no access rights across these parcels. But the way to solve that is to negotiate access rights, whether at the corner or somewhere else, so that public lands are accessible by the people that own them. Because, like, that's the other challenge here is that yes, the Wilkins property rights are at stake, but the public also owns all these parcels that they can't get to. Now they should have to pay for the access rights, but there should be some mechanism to do it. And if we get the rules set up correctly so that they're even-handed, fair, and clear, I think you'll see a lot more negotiation. And it won't happen overnight. Like there's a lot of landlocked federal land right now, but over time, the most valuable and desirable parcels will become open to the public because the Forest Service or Bureau of Land Management or their federal agency sat down with landowners and figured out how to do that.
And I'll add to that. I think if there's these strict rules that prevent negotiation, then you're going to get an incentive to never negotiate. If, like in this case, the previous owners, Forest Service needed access, and they said, "Well, we want it for these specific things," and the owners granted it. And then the Forest Service never came back and said, "Okay, well, actually, now we want more. So, is there a way we can work this out? Is there ways that we could?" And not just money. I mean, one of the big things is, in this case, is the Forest Service takes no responsibility for who it allows on. And that's the big thing, is that in most cases, if you own an easement over my land, you're responsible for the people who use it. But that's not what happens here. And that comes from a lack of negotiation. But if the government is going to if you give them an inch and they're going to take a mile, then you're just not even going to give them the inch. You're just going to say, "No, I'm going to walk away. You want this access. I've seen what's happened in other places that if you, and there's no way for me to resolve if you exceed what you agreed to, then there's going to be fewer people who even want to negotiate. And that's going to make it harder to access lands as well."
Thanks, Jeff. So I have a two-part question here. The first question is probably the most important question of the hour. I'll ask them both. So the first question is, did the cat survive? And then the second question is, in the case of Wilkins, what does the Forest Service actually have to gain by opening the road to the public?
The cat did survive. This was several years ago. It eventually passed away from old age, but it did survive the initial wound, and so yes, that is true. And then the second question, could you repeat that, Ethan?
It dropped off the Q&A, but I believe it's why does the Forest Service care really about what's in it for the Forest Service to grant public access here?
Well, as Jonathan said, access to public lands are important for a lot of reasons, and many people want to hike or hunt in this area. There are other roads into this specific area of the Bitterroot National Forest, but that's what the Forest Service would like, I think, is to have people recreate. The problem comes when they don't negotiate for that and instead try and use what was supposed to be something for very limited use, and try and get their goals without negotiating. And that's where the problem is, not necessarily their goals, just how they're going about it.
Yeah, just absolutely right. So the Forest Service has an obligation to provide public access opportunities on federal land that was imposed by Congress. And so often, it's not enough to say there is a road into this Forest Service section that might be hundreds of square miles. Like if you're really going to make it possible for the public to recreate and use that public property, you need lots of access points. So I mean, I'm very sympathetic to the Forest Service's predicament of, you need to provide access, but do you have the rights to do it, and how do you get them is a really difficult challenge that if the agency were to negotiate, might end up costing a lot of money. But really that's what it is. It's not that the Forest Service hates property rights. It's got this mandate that it's trying to satisfy, and it's often cheaper to try to take rights rather than acquiring them fairly.
Thanks. So another question here. I've heard that some public lands were allocated with easements for public access along the section lines. Is that the case here with Wilkins?
No, this was not the case. There is some checkerboard land around it, but the private property issue is fairly large. And no, what this actually, the easement came about in the 60s, and the Forest Service needed it for them. At that time, they had a mandate for timber harvesting. So again, mandates kind of tell you how the Forest Service acts. And so the Forest Service in the 60s came, there was no access point, at least on this part. They came in and said, we need access for our loggers. The property owner said, okay, pay, I think it was $150 for that. And that's what happened. They recorded the deed. And then it was later that when the mandate changed, but the easement didn't change. But the Forest Service, despite the easement not changing, viewed the easement in light of its new mandate rather than its old mandate.
Yeah, the section rule is actually a unique rule to South Dakota. Really fascinating. That has always been the case. So there's not like a takings implication there, but every single section line is a public highway that was reserved for that purpose. Because of the relatively little conflict that has been spurred by that, there are growing movements in other Western states to sort of break the corners, to say that every place where two public parcels meet, there's a right to cross. No resolution of that yet, but it's something that a lot of private landowners object to because they also own half the corner, and their rights are at stake there too.
Thanks. So I'm going to combine a couple of questions here because they relate to the same thing, which is basically what other legal hurdles are out there still, even after Nick and presumably after we win in Wilkins? What other legal hurdles exist to prevent property rights cases from being heard in court, and how prevalent are they? How often do those hurdles come up in property rights disputes with the government?
Well, one thing Jim mentioned, Pactel, and after Nick, there are some governments are trying to find new ways to keep cases out of court. And one thing that they tried to argue in Pactel, and they've argued in some other cases, is ripeness. And what they're saying, what the government says there is, well, we haven't actually made a decision. So if you say that this regulation is a taking of my property, well, jump through all of these numerous hoops, and maybe we'll change our mind. But you have to jump through the hoops, or else your claim's not ripe, and you can't go to court. And that is one hurdle that. I mean, there's another case the PLF had in San Mateo County in California. There's a portion in San Mateo County that is protected for environmental reasons, and it's very clear nothing can be built there, but there is some private land on there. And the private property owner reached out to the county commissioners. The county assessor said, oh yeah, you're never going to be able to build here. And so the private property owner said, well, that's a taking of my property because you passed a regulation that doesn't allow me to build anything, and went to court. And then the county said, well, you didn't actually file this form. You didn't do this. Maybe we'll change our mind. Maybe we'll allow you to build, even though the county assessor had said you're never going to be able to build. And those are the types of arguments that prevent. The ultimate question is, did the government take the property? How much do they have to pay for it if they did?
Great, thank you. There's a question here about really what other sort of solutions might be available in these kinds of situations. Is there legislation or bills that are being proposed or might be proposed or been proposed in the past that could be helpful to address these kinds of issues?
Well, I mean, certainly Congress can fix the issue, and it's interesting reading the legislative history of the Quiet Title Act. That's what Congress set out to do. And it was as Jeff said, this concept of sovereign immunity. You read the Senate report, the committee report, and it's quite clear that the Senate committee was horrified by this idea that the notion that the king can do no wrong is keeping people out of courts in the United States, keeping them out of court when they're seeking to protect their property rights. So Congress could easily fix this by amending the Quiet Title Act, but I don't think it's necessary for Congress to do that. If the courts interpret the Quiet Title Act properly, with an eye toward the text and the history and the context, then the courts can actually resolve this problem without Congress stepping in. But the Congress is free to shape the waivers of sovereign immunity in broader terms. And if it does so, then people will have more opportunities to get into court to defend their rights.
Yeah, and I'll add another thing Congress can do is make it easier for property rights to be the solution here. So one of the really effective mechanisms to solve these sorts of conflicts, so it's known as an exchange. So the federal agency will trade federal land for private land. So you eliminate the checkerboard, and you don't have to provide access through private land, but you can provide it through public land. But the rules for that and the procedure for that is so incredibly complicated that in most cases, it's easier for the agency to fight with a private landowner than go through that process. If that were easier, if the agency had more flexibility to secure those kinds of property rights, you'd have a lot fewer of these kinds of conflicts.
Thanks, Jonathan. Jim's comment touches on another question here, which is sort of about the broader picture of state sovereign immunity. Obviously, that plays a role in more than just property rights disputes. It's kind of an overarching issue. The question here is, could future property rights cases provide a vehicle to undermine the doctrine of sovereign immunity generally? And then makes the comment that sovereign immunity, the idea that the king can do no wrong, seems at odds with the American ideals of liberty and government accountability. So please, whoever wants to comment on that, I think it is an important overarching issue to note.
Well, as I've said, the Senate committee agreed with the questioner. I think I have part of the quote here from the Senate committee report. It's that sovereign immunity or the infallibility of the crown is not appropriate where the courts are established to serve the people. I mean, if you take that statement more broadly, it has pretty profound implications for a lot of the immunity doctrines that are in the headlines these days, qualified immunity probably being most familiar to most people, which is just a flavor of sovereign immunity. So I'm not sure that the Senate committee was contemplating the full implications of that statement, but taken at face value, it certainly suggests that there was, at least at that point in 1972, some consideration among some senators to pretty radically reform the idea of sovereign immunity. I don't know that there's any sustained push to do that now, outside of very specific reforms such as we saw a few years ago. But I don't know that there's a need for a radical revision in sovereign immunity, except in certain contexts. The context we're talking about now, what I mentioned earlier about state sovereign immunity from having to pay for federal takings claims. There's a tension in the case law around the 11th Amendment and in the self-executing nature of the Fifth Amendment's just compensation clause. And governments shouldn't be off the hook for violating the Fifth Amendment simply because they are state governments. And so that reforming that piece of it is an important part of protecting property rights. But a more radical revision is probably beyond the scope of this conversation.
So we have a question here, I think will nicely conclude our Q&A session, and then I'd love to get some final remarks if you have any. How does Wilkins help everything else that PLF is doing?
Well, we can't protect private property rights if we can't get into court. And unfortunately, a lot of our work has been at the just getting into court part because of doctrines like sovereign immunity or other judicial procedural requirements. And so, yeah, we hope that the court will make a strong statement about how property rights are the same as other rights, that people whose rights are violated have the right to get into court, have the ability to get into court, and have these resolved.
Thank you. Just any other final remarks before we conclude?
Well, thank you everybody for coming, and happy to answer any more questions. You can reach out to us if you do have any questions later next week or the week of the argument.
Thanks, Jeff. Well, thanks to all our panelists and all those attending today. Again, Wilkins versus United States, it'll be argued on November 30th. So please follow the case, and we will have exciting updates, I'm sure, in the months to come. Thank you.